Good morning to all of you. Welcome to Legal Matters by Vaibhav Sankara. This is a case relating to Consumer Protection Act, the decision given by NCDRC, National Consumer Disputes Redressal Council or Commission. The Commission clearly held that the buyer is entitled to get refund with reasonable interest if the project is incomplete. If the builder could not fulfill the requirements of the project, definitely he has to give back the amount along with the reasonable interest. This is stated in the case of Vaibhav Garg versus M3M India Ltd. CC number 269 by 2018. The decision was given on 29th September 2024. Of course, it's only award because it is NCDRC. They have a chance to go to the appeal to the Supreme Court also. Right? So, Mr. Binay Kumar, who is the president of or chairman of NCDRC, held that the buyer is entitled to a refund with reasonable interest if the project is incomplete on the date of possession. Coming to the brief facts of the case, better to know the brief facts of the case. As usual, ఇది గురుగ్రామ్లో జరిగింది. Mr. Vaibhav Garg, he booked a unit or a plat in the M3M Woodshire project. M3M Woodshire project constructed by the famous infrastructure builders M3M India in Gurgaon, Haryana. He paid 95% of the total consideration amount. But the conditions are unfavorable to him. After seeing the agreement, there was a delay of more than 3 years, 36 months. And when he saw the terms, he has simply signed on the agreement. But when he saw the terms, they contained all unfair terms in favor of the builder. Right. Despite promising that he will complete in the next 2 months, 6 months, like that, after 36 months also, significant delay occurred. And on multiple commitments also, even after multiple commitments, such as reducing the green spaces, not constructing the 2 basements for parking, and concealing the presence of the gas pipe lines, like that. But still, ultimately, he revised the building plan without consent. That means municipal authorities did not agree. Then he revised the plan without consulting them. Then he imposed extra charges, all these things. But ultimately, he failed to provide the satisfactory updates. He filed, now the complaint filed a case before the NCDRC. Ultimately, the National Commission, 5 lakhs for mental agony, refund of the entire amount plus 18% interest. Now, you have to see the contention of the builder also. How they try to defend themselves. He says, the calculation of the commitment period was miscalculated because the period from which the work started has to be taken into consideration. But he has taken the period from which the agreement has come into existence. యాక్చువల్గా ఫస్ట్ బేస్మెంట్ వేసిన తర్వాత నుంచి పీరియడ్ క్యాలిక్యులేట్ చేయాలి. అగ్రిమెంట్ డేట్ నుండి చేశారు. ఎస్, అగ్రిమెంట్ డేట్ చేయటమే కరెక్ట్. సెకండ్, ఈయన ది బిల్డర్, దట్ ఈస్ వైభవ్ గర్గ్, హీ failed to pay the installments in time on so many numbers. The complaint missed the timely installment payments. Right. This led to 10 rupees fine and things like that. Complainant contradicted the binding agreement. So please remember, and ultimately he is not a consumer. Please remember, he is not a consumer under Consumer Protection Act, and the Commission doesn't have jurisdiction over the contractual issues and no negligence. This is the defense. ఇక్కడే చాలా చోట్ల మనకి చీరాల్లో కూడా ఒక కేసు జరిగింది, అందుకనే దీన్ని ఉదాహరించడం జరిగింది. నార్మల్లీ మన్నం ప్రైడ్ అని చీరాల్లో ఒక అతను కన్స్ట్రక్షన్ స్టార్ట్ చేసి ఇదే ప్రాబ్లం వచ్చింది. అండ్ హీ సెడ్ హీ ఆస్క్డ్ దెమ్ టు కమ్ టు ది ఆర్బిట్రేటర్ బికాస్ ఎ క్లాజ్ వాజ్ దేర్. బట్ ఇన్సిడెంట్ ఈస్ దట్ హీ చీటెడ్ దెమ్. సో క్రిమినల్ కేసుల్లో ఇది పనికి రాదు. అట్లాగే ఇతను కూడా he wanted to drag the matter to arbitration conciliation, but anyway, the observations of the national NCDRC. So please remember, the manufacturer, the builder was deficient in meeting the advertisement commits. Here, the complainant has got a right to seek a refund. Right? The builder has not completed the project within as per the agreement, as per the brochure, as per the amenities like clubhouse and other things he promised. He promised to construct a shopping mall also at the time of position. He did not do anything. Definitely there is deficit in it. And please remember, the builder is he wanted to hand over them deficiency is accepted. So basing on the precedent in the case of Rajan Honda versus M3M, same people, India Developers Limited. So definitely the builder has to repay the refund amount along with the reasonable interest plus 5 lakhs for the mental agony. Right? So MGM, their headquarters is located Golf Course Road, Sector 454, Gurgaon, and so many. Atul Kumar Verma, Ashish Agarwal, then Om Shankar Sharma, so many people, Vivek June and another. Then M3M India, of course, they are the same. So all these people instituted cases against this M3M. So ultimately, the final order or award was declared by the NCDRC. As already I told you that these people have got a chance to go to the Supreme Court of India. The decision was given on 28/9/2024. Please go through the judgment, and definitely you will have good knowledge on consumer law. Thank you very much.